Welcome, everybody, to today's episode of It's Your Right, brought to you by the Stanislaus County District Attorney's Office Victim Services Unit. My name is Courtney Martin, and I am an advocate here. On today's episode, we're going to be talking about domestic violence. Domestic violence is not only an issue here in Stanislaus County, but in the state, the country, and even worldwide. Domestic violence is the number one killer of women worldwide, and men are equally likely to be victimized by domestic violence. Today, I have a couple of guests with me here. Would you guys like to introduce yourselves?
Hi, I'm Detective Davis with the Modesto Police Department. I've been a police officer about 6 years, a detective of almost 3. I really have a passion for domestic violence. That was my goal, was to be a detective in domestic violence. Growing up, I was about 15 to 16 years. Lived in a household that was part of domestic violence and abuse. So I really have a passion for it, and that's why I chose this position.
Wow, thank you for sharing that.
Hi, my name's Ahnna Reicks. I am a deputy district attorney here in Stanislaus County at our DA's office, and I equally have a passion to speak up for those affected by domestic violence. I was formerly a police officer when I lived in the state of Iowa, so I got to see it from that perspective, like Detective Davis and in his shoes, when you're called out to the homes of those people that are being impacted, and got to see it firsthand. Here, when I moved to California, I became an attorney and specifically a prosecutor, and here I am able to see it from the standpoint to represent the victims in the courtroom. My current position with the office is to review the cases that come into our office for issuance and determine whether we're going to file charges or not file charges in a particular case.
Thank you for sharing that. For me personally, I am a victim advocate here with the District Attorney's Office. I have been an advocate for the last 2 years here. And the reason why I came to work for the District Attorney's Office is because I really wanted to help give victims a voice in a time that they feel like they didn't have one. Growing up in the community, I grew up in a very small community where I could see a lot of households and be torn apart due to intimate partner violence. And so I really wanted to come and hopefully make a difference and give people a voice that they didn't think they had before. So thank you guys both for being here. Today, we are going to try to talk about some misconceptions with domestic violence cases, answer some common questions, and we're hoping that we can build a better relationship with the law enforcement agencies and the District Attorney's Office here in Stanislaus County. So I'm going to start off. I'm going to go right into it. Detective, one question that we get often is, why does law enforcement make an arrest instead of de-escalating a situation?
Well, the Modesto Police Department, our response to incidents of domestic violence and violations of related court orders, we kind of stress enforcement of the law to protect those victims and communicate that domestic violence is a criminal behavior. It's also our policy of the department to facilitate victims and offenders to access to appropriate civil remedies and community resources when that's feasible too.
Well, thanks for sharing that, Detective. So one scenario that we get a lot from victims is they'll say they call 911 to have law enforcement come and just calm things down, to get the suspect to leave the scene, but they end up making an arrest. So can you talk a little bit about citizen's arrest or when it's absolutely needed?
Well, to talk about that, California, which I'm very happy with, we have very strict domestic violence laws. Within those, one of the California laws, it says an arrest should be made when there's probable cause to believe that a felony or a misdemeanor offense had occurred. So officers at that point, once they learn that elements of that crime have been committed, we are going to make an arrest. We see it from the victim standpoint too, is they just want that immediate response. They want that immediate safety, and trying to explain to them that we are there for their safety sometimes gets a little misconstrued, even though we're abiding by the California state law. but our main goal is to keep those victims safe.
Thank you. So when law enforcement is unable to make an arrest, so the suspect's at large, can you talk about, what officers will do when they're at large, like when a warrant or information and belief will get issued?
Yeah, sure. Initial response is usually going to be like a patrol officer, and our patrol officers are going to make every effort to attempt to locate that person, that batterer or that abuser. If they can't locate them, say they've fled and we're unable to locate them, officers, if it's a felony situation or maybe a misdemeanor involving a felony situation, those officers will issue what's called an information and belief warrant or possibly a Ramey warrant.
Once those warrants do get issued, does law enforcement actually search for the suspect, or do those reports just get forwarded to the district attorney's office?
Felony domestic violence reports, or say a misdemeanor that involves a felony report, those will get forwarded to the special victims unit, which myself and my partner will usually get assigned. Once we're assigned those cases, we'll make every attempt to end up locating those suspects. We do a lot of things to do that. I don't want to mention those things on here because that will kind of hinder our investigations. And also every week a list is sent out to our patrol officers, and when they have time and time permits for officers to do those checks, they'll go out and check for those people too. So we are out there, and like I said, our main goal is the safety of the victims.
I'm sure that's going to bring a lot of peace to some people because, once victims are in that situation, sometimes they don't know what's next. And so knowing that, law enforcement is out there and doing what they can to try to make that arrest, I'm sure that's going to bring a lot of peace to some people. So thank you for explaining that. I want to kind of talk a little bit about a question that we get often in regards to victims being confidential on police reports. So can you explain, as for law enforcement's perspective, what it means to have a victim listed as a confidential victim?
Yeah. If a victim elects to confidentiality, that means their name, address, their business address, school, telephone numbers will not be disclosed in our police reports. Throughout the report, if you're reading it, it'll say confidential victim, or CV for short. And we'll usually ask the victim if they request to be a confidential, and if they say yeah, we'll have them sign a form for that.
Okay. So bringing it to the district attorney side, because, they're listed as confidential on the police report, but then that report gets forwarded to the district attorney's office. Ms. Reicks, do you mind explaining a little bit about, why a victim's information may be listed on a criminal complaint, or when that report might get discovered to defense?
Sure, absolutely. So first of all, a complaint is a document that we file in court. What that document says, it lists a particular defendant's information, as well as any crimes that we are charging that defendant with. So set that aside. To answer your question, each one of us has a constitutional right to know if we're being accused of something and who that person is accusing us of what we did. And we have a right to confront that accuser. So these constitutional rights are inherent in each one of us. When we file a complaint in court, what it does is we need to give that particular defendant notice. Here's the charges that are being filed against you and the particular crimes. It also serves a second purpose as well, as it also alerts the court who a particular victim is of that crime. So if we had a scenario where we had a defendant who went out and committed a burglary on Monday, and that burglary was to the gas station, and then the following day, Tuesday, that defendant committed a burglary and he or she burglarized the library. And then on Wednesday, that same defendant went out and committed a burglary and they burglarized the auto repair shop. When we would file these charges, we may be alleging 3 separate burglaries that occurred, but we need to identify which victim is who for the burglary. That would tell the defendant you're on notice for committing these burglaries at these particular dates on to these particular victims or businesses, And also, it allows the court to do something. It allows the court to say, defendant, you need to stay away from these particular businesses. And it also gives the court the ability to assess and assign restitution for the defendant to pay restitution back to those businesses.
On the side of the complaint, there is something that's called discovery, which is just evidence that gets submitted to the defense because they have a right to the evidence that we have due to the Brady laws. So the confidential victim's name is on the police report. Does that report get discovered to the defense?
Yes, that's a very, very, very good question. So Detective Davis commented how all of the victim's personal information has been redacted out of the police report. So if somebody is trying to seek those reports from Modesto Police Department in this case, or any other law enforcement agency, all of that information would be redacted. However, when we provide discovery, and because of that constitutional right, we need to provide discovery, which would include that information to defense counsel and the defendant so they know who the particular person is that's accusing them.
Okay. While we're on the topic of the reports here in the district attorney's office, I am going to ask more about criminal charges and the victim's wishes, whether or not charges get filed. So, Detective, do you mind, providing us a little bit of information on why law enforcement will ask a victim whether or not they want charges filed?
So an officer responding to a domestic call, sometimes we can't make an arrest. So we can advise him or her of their right to make a private person's arrest. That advisement, we usually remove the suspect from that location or away from that victim and ask them in a disclosed area. So that way that offender is not seeing that victim being asked that question, because sometimes that will place fear within that victim. And it's very rare on occasion that we'll have to ask for that, because most of the time those elements of the domestic violence have occurred and we can make an arrest on those under California law.
Does law enforcement ask a victim whether or not they want charges to be filed?
Yeah, that's a really common question we do ask. A lot of times it all depends on the victim. If it's someone who's been in that type of relationship for a long time, they may say no. And that's where we come back to your initial question is, hey, I just called for help, and why are you arresting him? And there's a lot of things that play into that. It could be they're financially supportive of that person. It could be childcare. There's a lot of things that go into that, and we take in consideration that. But like I said, the end goal is going to be for that victim's safety, and that's why we have to do what we do.
There's often scenarios that even though the victim has expressed to the officers that they don't want charges to be filed or that they don't want the suspect to be arrested, due to the California laws, those reports still come to be reviewed by the district attorney's office, where the district attorney actually is the one to make the decision about criminal charges. Ms. Reicks, do you mind explaining a little bit about that? And does the district attorney's office consider whether or not the victims want to file charges when they're making that charging decision?
Yes, very, very good questions. First of all, the district attorney's office cares very much about what the victim's position is and their perspective. We do take that into account, whether they want to have charges filed or they don't want to have charges filed. However, it is critical. It is super important to know it is not a victim who gets to decide whether charges are filed against a particular person in a particular event. It is the district attorney's office who does that. A victim is never to blame if charges get filed. A victim is never to blame if charges don't get filed. It's on the district attorney's office who does that. And what we have to do is we look at a case and we make that determination after that arrest has been made, or if it's a case where the offender is gone and a warrant might be out for them, and the law enforcement agency has submitted the case to us, we're going to determine, has a crime been committed, and can we prove that crime beyond a reasonable doubt? If that's so, then we're going to file those charges. I will tell you personally, I have seen cases that have come in for review where victims want charges to be filed. And I can give you an example of something that I just had recently. I had 2 neighbors that are disputing and they want to file charges on each other. In that particular instance, we review the case and we determine there isn't a crime that we can prove beyond a reasonable doubt here. So no charges are going to be filed because of our standard and what we can prove in court, even though the victims in those cases want to file charges. There's other times, on the other hand, where victims, especially victims of domestic violence, do not want to have charges filed. And Detective Davis really hit on it. There is a number of reasons why they may not want to have charges filed. They might have kids involved in the picture. They might be scared because, you know what, if I file charges, it's just going to get that much worse. They might not be able to afford a house or the income, and they're reliant on that offender. There's a number of things, but we never ever judge why that victim doesn't want to pursue charges. We're looking at it for what we can prove, because our goal at the district attorney's office is to protect that victim and protect that family and those kids, essentially.
And, you bring a really good point. It's to protect that victim, to protect the family, but it's also to protect the people of the state of California, because it's just statistically, a person, if they're involved in intimate partner violence, it's either not their first time or it won't be their first time. There's going to be incidents after that. And so one thing that, we like to, as advocates, explain to the victim is, we hear you, you have the right to be heard, but at the end of the day, the decision is on the district attorney's office, and there's all kinds of levels that they have to review when they're making that decision. So thank you for helping to clarify that.
And you actually bring up a really good point, Courtney, because part of this is to empower them. Maybe they're not at the stage in their life to speak up quite yet, for whatever reason it might be. But it also is, especially for the resource of the advocate, to share with them and listen to them that no one deserves to be hit. And we will help them through that process, especially from an advocate standpoint, and hopefully to break that silence.
Another question that we get often is, what happens after a report is made, but a victim says, I have additional evidence or I have additional information? I know at least here with the district attorney's office, we're not allowed to receive statements or new evidence on a case. And so we'll often refer them back to the law enforcement agency that took the report to file what's called a supplemental report. So Detective, do you mind sharing a little bit about what you suggest for victims who want to add additional information to their original report?
Yeah, I would be happy to. It actually helps our cases and helps build those cases for those victims who want that prosecution. If they have additional information, they should definitely contact our police department. If they can give their name, or if they have a case number, which the officer should have gave them. That way that whoever they're talking to on the phone, they can send those people to the appropriate detective or officer. Victims are encouraged to provide further information and evidence. For example, if a victim was struck in the face and the injury was red when officers were on the scene, but that redness has now turned into like a visible bruise, that victim should definitely call, and we'll definitely send someone out there to take a picture of that, and we'll add that to the case file. It just, like I said, it helps our case when we send it over to the district attorney's office when she was speaking about reviewing cases.
Okay. And alternatively, if the victim makes a police report and they feel that there was some information that maybe was reported incorrectly, because as we know, trauma can have an effect on a person and a person's memory. In those same scenarios, would you still recommend that they file a supplemental report to clarify? Or, maybe they said, just an example here, they told law enforcement that it was a punch, but really it was a slap. And now that they have some time to think about it, they remembered and they want to correct that on the police report. Would you have that same advice to file the supplemental report?
Yes, absolutely. And as officers, we understand that trauma, right? They just went through something very, very traumatic. And when we get there, we're asking them tons of questions. And some things may get misconstrued. Definitely, if they take that break, they're able to calm down and they're like, oh, I forgot to say something, or that wasn't exactly how it happened. And they start to remember. Definitely contact us, contact a detective, whoever's handling that case, and give us that information so that we can add it to the reports.
And Ms. Reicks, can you explain a little bit about why it's so important for victims to make that supplemental report or speak to an officer when they feel that they have additional evidence from the district attorney's perspective?
Yes, that's really critical. It's because we want to get to the truth of the matter here. And when that victim, or even maybe somebody that was a witness to the crime, it could be somebody that was within the household or somebody that was on the phone for 911, whoever it might be, has additional evidence, that it's critical that they give that to the law enforcement so we can get to the truth of what's happened. And as Detective Davis explained, there's times where it's such a traumatic event and so many things are happening that maybe when the officer was asking a question, they didn't ask the exact question, so the victim didn't feel like they were able to tell the entire story. Regardless, we're going to get to the truth at some point, and we will have that opportunity to do it within the courtroom as well.
Thank you for that. So let's talk a little bit about restraining orders. So often we'll get reports where we'll get victims calling us saying that they have a protective order, whether that is a domestic violence restraining order, an emergency protective order, or a criminal protective order. And the defendant keeps violating that protective order. So, Detective, do you have any suggestions or recommendations for victims when they have these ongoing violations?
Yes, and just to clarify, these kind of violations, they're very serious because it's already showing that person doesn't really care about the law, and they're going to go back there to control and empower that person to say, hey, I don't really care what this law says. I'm going to come back to your house. Victims that are seeing this, they should report each violation that's occurring to officers or detectives. We can use those ongoing violations to determine if other crimes are being committed. For example, continued violations that involve maybe a threat that may lead to a felony stalking case. Now we can go arrest that person on a felony crime if it was just regular misdemeanors at that time. It gives us a little more power. It gives us a little more help on our end. Like I said, they should report. If it's just a phone call, we want to know if there are any kind of violations going on.
And one thing us advocates like to do and explain to victims is to document each violation and to keep a record of it, so that way when they do make the report with law enforcement, they can give an accurate depiction of the violations. And another suggestion that we make is that they document or record, take screenshots, pictures, videos, any evidence they have, submit it to law enforcement when they're making that report about the violation. And Ms. Reicks, can you explain, as far as like the district attorney's side, why that evidence is going to be so important?
Anytime there is a protective order in place, and you listed, Courtney, you listed a number of different types of protective orders. So it could be a family law protective order, from a domestic violence restraining order, to something when the police officer responded to a scene and contacted the judge, and the judge issued an emergency protective order, or something that's filed in criminal court, which is a criminal protective order. Anytime there's a protective order in place, that means a judge has said this particular defendant is supposed to abide by these particular provisions and conditions. And it might be no contact whatsoever, or it could be peaceful contact. And I know we'll get into that in a little bit. But if that person is not abiding by what the judge said, for example, if it's no contact whatsoever, there's a reason that we need to know about it. That defendant needs to be held accountable for his actions or her actions for the underlying charge. They're not supposed to contact the victim and potentially try to dissuade them and make them feel bad for the charges that are filed against them or manipulate them. Domestic violence is a cycle of violence. And once they get in that cycle, a lot of times the offender will try to use manipulative tactics to get that victim to drop the charges or to recant, things like that, instead of actually being held accountable for their own actions and their own behavior. And ultimately, the whole purpose of this is to get to the truth and to have that accountability. And eventually, whatever the repercussions might be, it could be something where they need to attend classes and learn different ways to handle their anger, or it could be things that they need to do for community service, or it could be they need to have some jail time, whatever the judge may determine in that case. But it's not to be put on the victim. It's to be put on the court, and the court is to hold that defendant accountable for his actions. So it's really critical that we know about any of those violations of protective orders.
Thank you. And you bring up a really good point about the different types of protective orders. And there are, it could be a peaceful contact order, or it could be a full stay away order. So, Detective, can you explain on law enforcement's perspective of what does law enforcement look at for those protective orders? What are they when they're being called out to a violation?
When officers are made aware of a protective order, officers will review that order to see who's listed as a protected party, the restrained party. We're also going to be looking in there to see who was granted custody of the children, or if there is a custody order put into that order. The big thing is if it has been served yet. A lot of people don't know that if it hasn't been served yet, and say that offender is there, as law enforcement, we can come there and serve it at that time. We're also going to be looking at the expiration date and the terms of the order. Like Ms. Reicks said earlier, is sometimes it may say peaceful, but in there it says, they can't be fighting or harassing or stalking this person. And if we see those elements are in there, but they think, it's just peaceful, that, he hasn't hit me yet, we can still make an arrest on those orders to protect that victim.
Awesome. Thank you for clarifying that. Another aspect of the protective order that you brought up was about children. And there may be some exchanging of children in the protective order where it says they're allowed to have peaceful contact where it comes to the exchange of children. So can we maybe address safety tips for exchanging children due to a custody order, whether or not there is a protective order in place, but when there's prior domestic violence?
Yeah. Victims of domestic violence were normally informed of our child exchange parking spots at the Modesto Police Department. Those have cameras. It's at the police department, so that should help the victim feel safer for a child exchange. If both parties are unable to meet at the police department, we usually ask to exchange in a public parking lot. In some cases, we ask maybe a grandparent's house or other friend or family that's mutual, that's not going to choose one side or the other.
Speaking of children and children in domestic violence relationships, have you in your profession noticed that domestic violence can affect children who are in the home that may have witnessed it?
Yes, and that's a very good question. So children, they're usually traumatized by the fear, and that could be fear for their mother or father's safety. Children will start to blame themselves for the violence that they're seeing within the home. And what's really sad is children will learn violence in their home by watching this violence occur between their parents. A child's exposure to, a batterer abusing the victim is the strongest risk factor for transitioning violence from one generation to the next.
Yeah, I would agree with that. Exactly what Detective Davis just said. Behavior is learned. And when although the victim is going through this instance where the offender is being violent with them, whether it's the put downs verbally about maybe body shaming or about how smart they are or how dumb they are, whatever it might be, those children are listening, they're watching, they're seeing, and eventually what they're doing is they're repeating it. So it goes twofold. I have seen it over and over again with the cases that are coming in, that child is seeing it's okay for mommy to get hit. And so that person grows up and gets in a relationship where they themselves believe it's okay for them to be hit. Or on the opposite side, they're seeing it's okay for mom to hit daddy. And so then they grow up and they equally become violent because that's what they believe and they've learned. I know we just spoke about the differences between the protective orders, and I wanted to throw in one really important distinction. There's times when the court is going to issue an order that's a complete stay-away order. It doesn't mean that that complete stay-away order has to stay in place the entire time. And there's reasons why the court, being it, issues the complete stay-away order. It's to protect that victim and those kids. Oftentimes, when a defendant or a offender might start going through classes and learn other techniques and things like that, we can come back on behalf of the victim and we can request a modification so that they can now have contact, and it could be a peaceful contact or what we would call a no harm, no strike to that particular victim. So there's times where after the offender has, shown themselves that they can change and have done so, where the court's holding them accountable, we can definitely do that. But most importantly, not only it's for the victim, it's for those kids, so they grow up in a nonviolent household.
Yeah, and thank you for clarifying that.
Yeah, can I just add something about the child exchange? Something I see that's pretty often is, power and control is the total of the abuser or the batterer. That's what they want to have. And if a victim's taken the steps and she's proceeding to move on and there's a restraining order, but the restraining order states that, hey, there's visitation. Or if after this has moved on and the victim's at a point where she had left that relationship. What I want to say is, if that offender is more than likely going to use those kids to continue to harass that victim. And if that victim feels like this is harassment, they need to report that to the police department. Even if it's not a crime, at least that's going to be documented for future things that are going to be happening. Because what they're going to try to do that I see is they'll try to use those kids to make the victim feel guilty for leaving. So definitely make a report and file it, just so at least we have it on hand.
And you bring up a really good point about the defendants using the children as a part of that power and control. One thing as an advocate that I recommend to victims, whether or not they decide to stay in a relationship or get away from that relationship, is to get a custody order in place, to get an actual court order that specifies the custody, whether it's an agreement between both parents or they go to court and have someone mediate. Having a order in place allows law enforcement to be involved. So, for example, both parents are considered to have parental rights if there's no custody order in place. There's nothing preventing one parent or the other to take the child and not return the child back to the other parent, even if they had a verbal agreement, even if they wrote something down on paper. Whereas if they had a court order specifying dates and times, if the one parent is not abiding by that court order, the other parent can contact law enforcement to intervene. So that is one advice that I would give to all parents that are trying to co-parent, whether or not there's domestic violence or not in the household, is looking into getting a custody order in place. So let's get into a little bit more serious of a subject. Let's talk about strangulation, because strangulation is a big part of domestic violence. And statistically speaking, if an individual is strangled, they are 7 times more likely to be killed. So, Detective, can you talk a little bit about some of the things law enforcement does to assess strangulation when they get a call to domestic violence?
Yeah, great question. Like you said, strangulation is very dangerous because of the possible injuries that may have been caused internally. Officers are required to contact paramedics for victims who reported strangulation. Victims are encouraged to seek medical attention if their symptoms persist. 24 to 28 hours after strangulation occurs is very critical for a victim. Strangulation can cause death if injuries are not treated. The Modesto Police Department, we recently just revamped our domestic violence forms. We have separate forms for domestic violence. Our new forms contain 2 sections which help gather evidence with strangulation reports. The first section is going to cover how strangulation occurred and the details of that strangulation. Just for example, some details would be, hey, did they use one hand? Did they use 2 hands? Were they in front of you? Were they behind you? We kind of go into very detail because of the seriousness of strangulation. The second section of that document is going to be more focused on the victim, what they suffered from their injuries, how they felt after the strangulation. So like I said, we take it very serious, and we try to document everything we can on strangulation so that when we send that report over to the DA's office, they can file those cases.
And, thanks for bringing up the point about, how the victim feels in the 24 hours after, because that kind of leads us when we were talking earlier about some of the evidence that may be after the report. So, for example, if a victim was strangled, they may not have markings, they may not have bruising the day that law enforcement's taking the report, but, some of those signs and symptoms can show up at a later time. Do you recommend that victim comes and files a supplemental report to make sure that that's all documented appropriately?
Yes, absolutely. And just another thing that we've noticed is sometimes a victim may not know they go unconscious because of that traumatic event. And they may have been abused while they were unconscious, and they may have other injuries that when they got home or took a shower, they noticed in a mirror. They should definitely call us and contact us so that we can come out and take photographs of those injuries and add it to the case.
And I did kind of want to talk a little bit about the word strangulation in general. So sometimes victims will use the word choked. They choked me or suffocated me. Can you explain, either one of you explain the difference on the legal side of it between choking and strangulation? Is there even a difference?
Yeah, and it's very common for that. Choking is like maybe a foreign object inside the throat, a piece of food or something like that. But we understand as law enforcement because we've had training and we conduct training to know the difference. And in our police reports, we'll usually put, the victim stated she was choked, but beside that, we'll put strangled. And once we start interviewing them and getting more specifics, that'll explain the difference in that. Strangulation is closing off the airway from the outside pressure on the neck or in the throat area. And again, choking is from the internal area.
Thank you for clarifying that.
And I would like to reiterate what you both have just said. Strangulation is serious. You said at the very beginning, Courtney, that the number 1 killer of women worldwide is domestic violence. And women or men, anybody that is strangled, they're 7 times more likely to die of domestic violence when strangulation is introduced. It's really, really, really critical that if strangulation has taken place, or whether they call it choking, whatever it might be, that they actually seek medical attention. Because just like an example that Detective Davis gave earlier, when somebody might have been hit and they have a red mark as soon as they were hit. The following day, all of a sudden they notice the bruising starts to take place. That's the same thing that happens with strangulation. That inside has been compressed. So those blood vessels, there are hyoid bones, other vessels inside the neck, had that pressure on it. And now that pressure is building, whether it could be the swelling, whether it's the bruising inside. And as the time goes on, it can affect their vocal cords. Their voice might be changing. It can affect whether they can breathe because of the swelling going against their larynx. And essentially, it can escalate to a point where it can obstruct their airway. They could even die from a stroke or death because they might start to feel sleepy. And again, I believe Detective Davis made a very critical point. Strangulation, when you're strangled, you may lose consciousness and you may not know how long you were out. Those are very critical facts, very, very critical facts because it's very serious. And you need to have that medical attention no matter what you do.
And thank you for bringing that up because, sometimes victims will say, well, I don't have any bruising, so it wasn't really that bad. But it is possible to have other signs and other things internal without maybe the outward appearance of the bruising that can affect the body. And so it's just going to be really important to make sure that you pay attention to your body, you write down any symptoms that you're having, and to seek medical advice after you've been strangled.
Yeah, and just something to talk about too is when going back to that victim confidentiality sheet that you were talking about, when a victim requests to be confidential, at the bottom of that sheet is a medical release for the police department, and we ask victims to sign that medical release. And if there is no injuries, and we ask victims, hey, you probably want to seek medical attention after being strangled, or if it's a severe injury from physical abuse, with them signing that form at the bottom, that gives us law enforcement the ability to obtain those healthcare records. And if it was a strangulation case and there was no visible injuries, there may be internal injuries. And once we get those records, we can add those to the report when we send it over.
Thank you. Can you explain to us what the Modesto Police Department specifically is doing to combat domestic violence here in Modesto?
Yeah, we're always looking for new things, and we're always pushing. Recently, the Modesto Police Department conducted what's called a domestic violence initiative. The DV initiative entailed detectives obtaining weekly addresses where domestic disputes occurred throughout the city. Those were from verbal arguments all the way up to felony domestic violence. Myself and my other detective, we responded to those addresses and contacted those involved parties. We conducted a survey with them, and we provided them resources and information of what kind of help they can get in the area. We did this for 6 months. We're going through all the data that we got from that. We're actually, MPD is working on making some new changes to that and continuing that initiative. Some other things that we're doing, like I mentioned, our DV forms are recently updated with more questions regarding strangulation and gun violence restraining orders. MPD detectives, we've been working really close with our DA's office. You can ask Ahnna over here. I've emailed her multiple times. I talked to other DAs over there. Our main goal is to be a team, especially with the victim advocates. We work along with you guys. And I think if instead of just us being solo out here, if we do it as a team, we can help keep these victims safe. And that could be something as simple as asking the DA, hey, what else can I add to this? Or what else do you need from us that our officers and detectives can take care of, that we can make this happen to keep these victims safe? We actually, going back to the Victim Services Unit, MPD Investigation Division, we actually opened up a desk for the Victim Services Unit to come over there. So we have an advocate available for us. Talk to them, because sometimes, like we talked about earlier, there's many things why a victim would want to drop charges or not proceed with that. And as advocates, you guys are specialized in that. And it could just be looking over the desk and saying, hey, can you give this victim a call? I'm not, she's not clicking with me or him. And I think that's a great resource for us. And then we're in the beginning stages right now, but we're having talks about a DV resource day at the police department. And hopefully that would be the DA's office, Victim Services Unit, the Family Justice Center, the Women's Haven, and detectives and officers from MPD being there. So if anybody had any questions, they could come down to the police department on that day and hopefully get those questions answered.
And, thank you for bringing that up, about the different community-based organizations that are working along with the Modesto Police Department and the District Attorney's Office. There are agencies that are out there that can help victims and survivors of domestic violence. And so one thing that I would have to say as an advocate is if you or someone you know is a victim of domestic violence and they have a case or they maybe have reported it or not, contact the Victim Services Unit. And if they're in need of resources, we are definitely a good place to start, and we can refer you out to different agencies depending on your situation. And Ms. Reicks, do you mind sharing what the District Attorney's Office is doing to combat domestic violence here in Stanislaus County?
Yes. So domestic violence is one of our most prevalent crimes here in Stanislaus County, and we have a specific unit that specializes solely in domestic violence. There's 2 prosecutors assigned to this unit, and they handle it's most of the egregious cases, if you will, for domestic violence or the repeat offenders. So the individuals that have been convicted before for domestic violence and again are going back out, maybe not to that same particular victim, but maybe they've moved to a different victim because it's that pattern and control that they do, or power and control that they do. And so our prosecutors specialize in those areas. Otherwise, we work hand in hand with our advocates here as well, and take domestic violence extremely seriously. And we want to empower that victim. We want to be the voice for that victim, and we want to break the silence and this cycle.
Thank you. And so to end this podcast on a little bit of a lighter note, I want to go into a little bit about personally, after you guys have had maybe a difficult case or even a difficult day, what do you guys like to do for self-care? So I'll go first. Personally, for me, if I've had just a really rough case, one that is emotionally draining, I will go to a coworker. I'll take a 15-minute break, go outside, get a breath of fresh air, and just kind of decompress. But if I've been having a rough day, it's really important for me personally to recharge my battery after work. And so I'll take even 30 minutes to an hour each day just to decompress. Personally, I'll either take a walk or watch some TV and just take that time to decompress, to recharge so that I'm ready and fresh the next day. So would you guys like to share what you do for self-care?
One of the things that you just said, and it really stuck out to me, Courtney, was that if you had a rough case, and I think it's really important to know that the victims that are going through these cases, they've lived it and are living it. And so we equally can see that. And although we're separate as a prosecutor, an advocate, or a detective, we're also human beings, and it affects us as well. And we see it not just in their particular case, but a lot of the cases that are in front of us where we're trying to protect them. So at the end of the day, we're also human, and it's important that we have that out, if you will. For me personally, I have some of the cutest dogs in the world, and they love going for walks. So it just lights me up to see them as happy as they are, no matter what kind of day you're having. And it makes you smile.
So thank you for sharing.
I really like having that out, and just want to reiterate to everyone listening is there is a way out. And I recently went to a class and was talking to a victim advocate who had been in a relationship with an abuser for probably 20, 30 years until he finally passed away. And what she said kind of hit home. She said, I finally felt free. And it kind of hit me is, working these cases over and over and just hoping that these people will find that way out and be free is kind of puts a toll on you after a while, because I have a passion for it and I care about my victims. So like I'll go home and I usually like to run. I'm a big runner, and just running, I just feel that freedom, because I'm more thinking about trying to make it that next mile than I am of work or anything like that. So running's a really big thing for me, and so just spending time with my family.
So you're a runner. Does that mean you're going to sign up for our virtual 5K during the National Crime Victims' Rights Week?
Yeah, definitely.
Awesome. Well, thank you guys both for being here today. We truly appreciate you. Stay tuned for our next episode of It's Your Right. This podcast was brought to you by the Stanislaus County District Attorney Victim Services Unit. We are here to help, support, and empower. Thank you.